very warm welcome back to the channel, and thank you very much for watching. In this video I wanted to talk about an emergency motion which may turn out not quite to be such the emergency that it purported to be in the first instance. But more generally, before I get to that, I want to explain a little bit about how litigation works, and so that the context of me talking about this emergency motion as it was proffered can be understood. So very briefly, just showing you the outline of this document as it is. It is defendant and counterclaim. Obviously, it's from the unsealed trove. It is defendant and counterclaim plaintiff Amber Heard's emergency motion for a protective order for all individuals. Now, that sounds quite an emergency on first reading, but you might find that you don't think so after you listen to this video. So, a little bit about the way litigation works. It is not simply about file a claim, go to court. We have the stages in between where you've filed your claim, and then there's the process of disclosure or discovery, as it's known in the United States, so that each party can look at all the documents that they want to examine and rely upon, and so on and so forth. Then there is the process of, in the United States, depositions. We don't really use depositions too much in England and Wales. I'll explain a little bit about those differences in a moment. But then also witness statements, other documents, evidence, and things like that, such as expert reports, some of which you might need the court's permission for, so on and so forth. There is also the issue of costing. So there are costs and case management hearings. And particularly in England and Wales, these are quite the thing, because we have different rules to the United States, whereby parties in England and Wales are responsible for the other parties, the other side's costs, if they lose the claim, as an ordinary rule, or if they fail to defend it, of course. But that is not written in stone. The court will retain the discretion for costs, and indeed we need to have cost budgeting exercises, and that is essentially telling the court what your costs might be, so that you don't go way beyond that and then expect 10 times the amount that you've initially estimated, because the court will disallow it. All of these things, and expert reports and various documents and witness statements and all of these sort of things, all need to be done in the interim between the filing of a claim, the submission of a defense to a claim, and the ultimate court trial. Now, as public and as prominent as this Depp Heard trial was, and you got to watch, if you so chose to, the entirety of the trial as it was broadcast live, what you did not see was all of these, for example, motions in limine, and these emergency motions, such as this one that I'm just about to talk about in this video. You didn't get to see all of those, but these are all part and parcel of a real litigation. And so sometimes there might be an emergency application. Let's say if one party gets wind of the idea that another party is going to dispose of evidence, or to leak some information, or whatever it might be, then that suffering party, if you like, can apply to the court for either an injunction or restraining order, whichever term you might understand it. So these obviously require court hearings. They require interim court applications. So you go back to court. In the United States, they are called motions. In England and Wales, they're called applications. We have an emergency application in England and Wales, which is essentially it's the same as an application, but as it sounds, on an emergency basis. So it's done in a much shorter time frame, usually given much more attention, and the rules for service are often made simpler. For example, I've been involved in an international kidnapping of a child case, where there was indeed an emergency application to injunct to prevent the party removing this child from the United Kingdom. This was then served by WhatsApp as opposed to by post, and it was heard by a High Court judge who'd probably just got out of bed, because it was about 11 o'clock at night, by telephone, instead of going into court. just to give you an idea of what an emergency application, or motion as it might be termed in the United States, what an emergency application would seem like. In this case, we had wind that this child was going to be removed against the other parent's wishes to another jurisdiction with which England and Wales did not have any particular methods of control. So if that child disappeared, was taken away, ultimately there was probably not a lot that the remaining UK residing parent could do about it. So this absolutely had to be prevented. Child was literally about to be taken on a plane, tickets were purchased, they were on the way to the airport, so on and so forth. So the only way to absolutely prevent that from happening by way of emergency application was to go to the High Court, obviously remotely, as I've explained, by telephone, with an emergency application which could then be produced to the airport to say this child must not be boarded onto this plane. And that was successful, and the child was not removed from the United Kingdom. That is an example of an emergency interim application, which was obviously in the midst of a whole load of other issues within that case with the child. And indeed, many different cases have these kind of emergencies. A totally different type of emergency might be something to do with intellectual property, where there's a design, or a new design, or a new recipe, or a code, or something that's copyrighted, or because once something is out of the bag and in public, then as it suggests, out of the bag, everybody knows about it, then the secret is lost. So if there were an ongoing litigation as to who owns it, and one party just suddenly said, well, I'm going to publish it online for everybody to see, then everybody's got it and you can't make any money from it. In that kind of case, if there were such a threat or such a real risk that that's going to happen, then again, one party could go to the court and make an application or a motion on an emergency basis to prevent, restrict, injunct this other party, this other person, or indeed this other company from publishing such material. And so you can see the nature of an emergency application. Now, the last couple of years have not been short of emergencies, with COVID, the pandemic, and all sorts of variants of that coming about, putting risk to different people. So with that in mind, that is ultimately the basis that in this trial, this emergency motion was based. But let me show you the motion first, and then I'm going to show you some of the communications surrounding it, and you can get an idea for what those arguments were. And I don't think I even need to comment or opine as to what I think. You can probably think that for yourself, but let's see where we go. So looking at this document now, hopefully you can read that this time. Let's get rid of that so it's slightly bigger. Hopefully you can read that. So this was a motion by Amber Heard's team, and says that moves this court for the entry of the attached protective order to ensure sufficient protection for all individuals attending the deposition of Miss Heard. So this was surrounding the deposition of Amber Heard. Alternatively, to permit the deposition to be taken by Zoom. So remember, with the backdrop, of COVID, this was an emergency application. So on the face of it, to ensure protection for all individuals, or to be taken by Zoom. On the face of it, that sounds reasonable so far. The grounds for this motion are set forth below. Ms. Heard must unfortunately bring this emergency motion because Mr. Depp, now this is important because this is making a statement to the court, remember, this is the application to the court, this is Amber Heard's lawyer saying this is a fact, this is why we are bringing this motion. So stating as a fact within this document, this emergency motion, it says, because Mr. Depp, 1, refuses to honour his earlier agreement in writing to ensure the same safety and health protocols will be in place that Ms. Heard implemented for the deposition of Mr. Depp. So just to restate it very clearly, Amber Heard's lawyers are saying that Mr. Depp is refusing to honour a written agreement to ensure the safety and protocols that they implemented for his deposition. That's the first thing they state to the court. The second thing they state to the court, number 2, demands that Ms. Heard violate the law by not wearing a mask while being deposed. And 3, refuses to require all persons present to wear masks consistent with the guidelines. Now, just to bear in mind, this was filed, date stamped January 6th, 2022. The date's important because of the email exchange. Now, this has hit the news. The news took a slightly gossipy approach to it, if I can, without being disrespectful, because it obviously sounded like a spat between lawyers. I'm taking this slightly more serious legal aspect of it and saying that this was an emergency motion filed with the court. And so I look at the emails behind it, which of course are part of the court record. Ordinarily, I would, just to be clear, I would not ordinarily condone the publication discussion publicly of people's emails between parties and so on and so forth. But this was part of the court record, so it is public record. It was only sealed for the duration that it was sealed. Now it's been unsealed. Now it's part of the public record. It is essentially part of the public record, and those email exchanges are part of that record. So within this, we have an email which is dated before the filing from Benjamin Chew to Elaine Brederhoft on the 31st of December, so some 7 days before. Now, this answers, I suggest, what the issue was and what Johnny Depp's lawyer's position was in respect of this motion even before it was filed. So you can draw from this what you will. So this is from Benjamin Chew. Dear Elaine, the suggestion that I or anyone on Mr. Depp's team would not take the health and safety of the litigants seriously is false and insulting. It is of a piece when you falsely accused one of my colleagues of a misrepresentation concerning document production, which turned out to be your own mistake, for which you never apologised. And when you falsely accused another of sexism, for which the conciliator reprimanded you, and for which you never apologised. When you took over as Miss Heard's third lead counsel in the case, I received calls from a respected Fairfax practitioner warning of this type of behaviour, but I'm appalled nonetheless. We will not be bullied, and I'm confident the court will again recognise your accusations for what they are. That I highlight because that is the backdrop of this exchange. This is the real answer to the motion, I suggest. As you know, I've already confirmed in writing that we will take all appropriate measures to ensure the safety of Miss Heard, her counsel, the court reporter, videographer, and ourselves. Specifically, at your request, I agreed to the protocol used at Mr. Depp's deposition at your offices in November 2020, when a more deadly variant of COVID was raging, and no vaccines existed. The fact that we agreed to conduct Miss Heard's deposition in California, which spares Miss Heard exposure to 2 cross-country flights, is proof of our efforts to accommodate her safety concerns, since we would have been entitled to insist that she fly to Virginia, just as you required Mr. Depp to fly round-trip from London 7 months before the trial was scheduled, at the time, before anyone had been vaccinated, and when COVID rates were high in both London and Virginia. Under no circumstances will we agree to the deposition being heard by Zoom. The importance of in-person testimony by the parties has already been acknowledged by both sides, and, more importantly, by the court. Indeed, now this is important, indeed our consent order allowing remote testimony specifically excludes the parties and experts from being allowed to testify remotely. So this states that there is a consent order, which means the parties, both sides, have agreed to this order, but it's a court order nonetheless, and it has the power of the court nonetheless, specifically excludes the parties and experts from being allowed to testify remotely. However, in the interests of the compromise and to address conceivable concerns about safety, we'd be willing to postpone the deposition until the COVID spike lessens. A courtesy you previously declined to Mr. Depp, and specifically we would consider the 3 consecutive dates in February, and then there was subsequent discussion about those dates there too. And so just a brief look at Elaine's email that preceded this. At 8:28 that morning, Benjamin Chu's was in the afternoon, but Elaine's email that morning was quite the reverse. And I'm not going to read it all out, but broadly, you can pause and read this if you want to, but broadly, it is accusing Mr. Depp's team of not taking seriously all of the cautions and the risks with COVID. So ultimately, this was an emergency motion filed for something which I suggest should have been just agreed between the parties and not resorted to court time. Now, the reason I bring this up in this video and explain some of the backdrop behind the litigation that affronted it is because this is the very reality, and this is one of the reasons I talk about this trial so much, because it's a public trial. It allows you to see the behind the scenes, as Andrea Burkhart put it, the making of the sausage, and all of the reality that goes behind this litigation. These fights, if you will, these mini fights behind the litigation. This really goes to show what claimants, defendants, plaintiffs, defendants have to go through. Now, you can either do all of this yourself, which can be very daunting, very difficult and challenging, or you can pay lawyers to do it. And this, sadly, is one of the main reasons litigation can become very, very expensive, because very often you can have lawyers who are not prepared to compromise, not prepared to agree, and then in cases such as this, launch an emergency motion application to the court, pulling parties into court to argue about it when it's really not necessary. I come across this a lot in my practice. I literally get phone calls to say, we've just come out of court, we've got this court order. The other side has already said they are not prepared to follow this order. What do we do? Do they have to follow the order is the obvious question. And if they don't, what can we do about it is the second question invariably. And the answer is simple. It's a court order. They must follow it, even if it's a consent order. So for those of you in England and Wales, or worldwide for that matter, but certainly in England and Wales, if you've got a child arrangements order or the equivalent in another jurisdiction, if you have an order of the court, even if it's by consent, where you and the other party, the other parent or the other person with parental responsibility, which might even include a local authority, if you have agreed to the arrangements for those children, where they live, with whom they spend time, when, where, how, and so on, even if that order is by consent, it is an order of the court, and it must be followed. And just as another reminder, parties to those orders should not make the parties publicly known in those orders. That is a requirement of the court. But these are orders of the court. But very often, as I said, one of the first things that we are asked is how to enforce these orders when another party simply refuses to do so, and what do they do, or do they have to follow it? And as I said, the short answer is they must follow it. It's a court order. What do you do if they don't follow the order? Well, the only alternative is to make an application for enforcement of that order. And so this emergency motion, I suggest, should not have been necessary. And by the look of, well, you can draw your own conclusions from Benjamin Chu's email and what he says. So I hope that's been enlightening, and I hope that's been useful. And throughout these videos, what I aim to do is give you as much guidance as possible, as much explanation as possible to not just this trial or these documents, but these are a very good way of bringing to light lots of these issues that many of you do face. So, as I say, I hope that was useful. I hope that you will come back to watch more. Please do like this video and subscribe if you find these videos useful. And as I said before, I would love the opportunity to discuss real cases and to give guidance on those cases, to point you in the right direction. So leave your comments and suggestions down below if you have a case you'd like us to talk about there. In the meantime, I thank you for your time and attention. Please do like and subscribe, and as always, thank you for watching.